Okay, we are live.
There we go. Hello, everybody. Rylan's in charge, so he's going to be moderating everything today. He also is doing all the banners. I guess I can only complain about them for so long before they say I don't have to do it anymore. So yeah, Rylan's in charge. Take it away, Rylan.
Wait, what? This is not what we agreed to. Okay, so I'll get started with my topic today. So as you all know, we all like to give these little stories about immigration news that has happened recently. And for my story this week, I wanted to talk about the immigration judge quotas that have been repealed or suspended by the Executive Office of Immigration Review. So if you have not heard of these before, in 2018, the Trump administration, they implemented a new quota system for immigration judges at EOR, is how I've heard immigration judges refer to it as, but that stands for the Executive Office of Immigration Review. And under these new quota requirements, the Denver immigration judges were required to more than double their caseload than what they had previously been doing, double their completion rate, because the quota was for how many cases were you actually completing. And they needed to decide 3.5 cases per day on average. Obviously, you can't do a half case, but overall, 3.5 cases a day, which is, if you have a very complicated immigration case, that can be quite a quick turnaround if you need to do 3.5 in one day or 4 in a day. And it clearly was putting a strain on judges to decide cases quickly, as it was doubling the amount of decisions that the Denver office was putting out. But it also puts a strain on immigrants as well, the immigrants that were in these removal proceedings. There's no discovery in removal proceedings, so immigrants have to rely upon freedom of information requests to get relevant information on their cases. And that, as I'm sure many of the viewers here might know, can take quite a long time to get relevant files. And sometimes you ask for things and you get stuff that isn't relevant to what you're looking for. And you can get very inconsistent results from one request to the next. So the inability to get the relevant information for your case, coupled with this fact that judges were now having to quickly, speedily decide cases, it posed due process rights for immigrants, or issues for due process rights for immigrants. So it was not a good thing. I used to work with immigration judge, and she, when she was just getting started, she was not very happy about that. Maybe I shouldn't have said that publicly. But on October 19th, an internal email from the chief immigration judge, Tracy Short, was sent out to all immigration judges throughout the country, saying that they were going to be suspending the quota system that had been implemented in 2018. And that was going to be effective immediately. So no longer is there this quota system for immigration judges. However, in the internal email, there's the chief immigration judge, Short, she focused on the fact that they would be thinking of new measurements for judge success, and additionally, they would be sorry, let me just think for a second. But the fact within the email itself, what was frustrating about it is that they were not focusing on the effect that these quotas were having on the actual people that were in removal proceedings. Instead, it was more focusing on how unfair the quotas had been between immigration judges, because some immigration judges, they focus primarily on family dockets, which you can decide 8 cases technically in one trial, because it's a whole family together, and so that would count as 8 decisions technically. So they would easily meet the quota requirements. Meanwhile, there were judges that were not based in family law, not based in family decisions, that would be struggling more because they didn't have all these cases combined together into one, so that they weren't able to meet the quota as easily as the family-based judges. Now, obviously, that's it was unfair for judges in different situations deciding different issues, but I think that the more important part was the effect that it was having on the individuals that were actually in removal proceedings. So for this announcement to say, hey, we know that it wasn't fair to judges, I wish, and to be fair, also it wasn't a public announcement, it was a private internal email, but I do wish that there was some recognition of the effect that it had on individual cases or individuals in removal proceedings, so that we can be sure that maybe in the future, whatever system that they are going to replace this quota system with will be more friendly to immigrants' due process rights. We don't know what they're going to replace this system with. They did say in that email that the new system would be implemented shortly. However, and we were unaware at this point of what that new system might be. We're hoping that it will be more friendly towards due process rights, but we'll have to see. At least we know that this quota system, which was forcing judges to speedily decide cases that maybe should not have been decided yet, or the individual needed more time to gather the appropriate evidence, we at least know that that is suspended for now, and we'll see where we go from here. So who would like to go next?
You're the moderator. You decide.
Zach, I hear you. So let's talk about the Facebook settlement.
All right. Well, we got some boring stuff for you here now. This comes down to really like the basis of employment-based permanent residency and how companies sponsor individuals to get permanent residency. The Department of Justice and the Department of Labor had filed a complaint against Facebook alleging discrimination against U.S. workers in their use of the PERM system, as it's called. This is the process by which it's kind of like a prerequisite to applying for permanent residency through your employer. It's on the spectrum of business immigration, there's like an employment authorization document is pretty easy to do, and then on the other side of it is the PERM process, which is just a whole bunch of regulatory hoops that don't quite make sense. I think the last time the process was updated was 2004, and it just doesn't quite work for the way the world works in 2021. Anyways, as background, Department of Justice is saying that Facebook has been discriminating against U.S. workers in favor of non-citizen workers in their hiring practices. They're alleging various violations and including violations of how this PERM process was run. A settlement was reached for a little bit over $14 million. Facebook alleges no wrongdoing, of course, and really it's just it's a huge mess for us business immigration lawyers now to kind of parse through this settlement, figure out what did Facebook do wrong, what do we need to do differently in our practice moving forward, and I guess how this is going to impact really the employment-based side of immigration moving forward. To give you some background on the PERM process and how it just kind of doesn't make any sense. There's really 3 steps to the process, and the way you should really conceptualize it is as being a test of the U.S. labor market rather than being a recruitment tool. First thing that happens is that a job is provided to the Department of Labor. This is the minimum requirements, these are the duties, these are the the supervisory responsibilities, all these types of things. This is where the job is going to be, and the Department of Labor comes back and says, all right, so here's the minimum amount that you have to pay this worker or this position based off of those facts. At that point, do some mandatory recruitment, and this is where things get tricky and don't quite make sense. This is supposed to be a test to show that there's no willing, able, and qualified U.S. workers for that position that the company was filing for. And so the Department of Labor says, here are a few mandatory steps you have to go through in order to test the labor market and prove that there are not these U.S. workers available. So, for example, you have to do 2 Sunday newspaper advertisements in the newspaper of widest circulation in the area. Because, when we're all job searching, that's the first place we go, is the Sunday classifieds. You have to do an internal posting notice so that your employees know that a job is being pursued under this process. And then you have to go through the state workforce agency. It's this basically the state Department of Labor that has its own website, and you have to post a job ad on that website. For most jobs, that's it. That's all you have to do. You're done. You've posted the online job posting in a website that doesn't get a lot of traffic. You have 2 Sunday newspaper advertisements, and you have internal postings. And if nobody responds to your advertisements, then that means there's no able, willing, and qualified U.S. workers. Even if you were to say, like, hey, let's put it on Indeed or Craigslist or something like that, and you would get dozens of applications because of it. It just doesn't really work for how the world works in 2021. In the past, the Department of Labor has gotten pushback on this whole print advertising requirement, saying people have literally said what I just said, like, this is not how the world works. And they said, no, we disagree. This is actually how people do look for jobs. And we can look at the newspaper and see that regardless of industry, this is the proper way that you would be advertising for a job. There's a whole bunch of other very nitty-gritty in the weeds things that go into this perm process, but that's kind of the main point I want to get across, is that it just doesn't quite make sense for recruiting somebody. It's supposed to rather be a test of the labor market. It's to find if there's anybody who's minimally qualified for a position, rather than finding somebody who is well qualified for the position or best qualified for the position, and somebody who you would want to hire. So what the allegations are for Facebook is that they have drastically different processes for their perm recruitment and their normal recruitment. So for example, on their normal jobs, they would allow for online applications. For perm jobs, you would have to mail in a resume. Obviously, if you have the option between uploading your resume or emailing your resume, you would go with the email over, buying stamps and getting an envelope and mailing it to a specific PO box. So it did place, additional burdens on the recruitment process. But I guess that's where I guess the core of this complaint is that if you're looking just at the normal recruitment processes, Facebook didn't follow those when they were trying to hire their own foreign nationals for permanent positions. Now there's facts out there that Facebook certainly didn't go through all of the good faith requirements that are kind of underlying this process, but by and large, to me, it seems at least that Facebook was following the letter of the law, if not the spirit of the law, perhaps, but they were at least, following what the law says we have to do. Put the newspaper advertisement out, put the internal job posting together, allow for mail-in resumes. If you have the Department of Labor supervise this process, they will have you mail in resumes. So to say that that is an overly burdensome process seems a little disingenuous to me. Regardless, in the end, whether it be because of press or because of ongoing litigation costs or whatever it could be, Facebook decided to simply settle the case and not litigate it to its conclusion. No wrongdoing that they admit to. They're going to pay a fine. They're going to go through some supervised recruitment with the Department of Labor, and then we're kind of left to figure out what went wrong.
Zach, do you think that that what is happening to Facebook now, prior to their settlement, is something that most employers are at risk of, or is it something that was special about Facebook? It's one of the biggest companies in the world right now, and so maybe it's getting extra scrutiny. There's many news stories about their dealings in all sorts of situations, and I know that the government might want to show them, you're not as invincible as you think you are. So do you think that, this does represent a risk to all employers, or is it a special situation here?
So I think there's really 2 levels to that. So the first, I think, is that Comparing small and medium-sized employers to Facebook, obviously it's massively different. If we have a medium-sized company, you're not going to be advertising the same position in 60 different at 60 different times and having one of them be a perm process. So I don't think that this is going to very much impact small and medium-sized businesses. I think it's much more of a concern for larger businesses that do this for a massive amount of people at the same time, or who are advertising a lot of the same position at the same time. And beyond that, the second level, I do think that there is something to be said about it being a big tech. And that's something that the government has been, I guess, kind of on for a while. We saw that during the Trump administration when they were really going after H-1Bs for tech workers. We're now seeing it perhaps in the perm process context with these tech companies having extra scrutiny on their petitions. What's a little strange to me is that when you do the perm process, there is a chance of randomly being audited. And given Facebook has so many employees, I would imagine that they've been audited before. The fact that nothing has really come of it until now, into this big complaint about discrimination, it's odd to me. But that's again where we don't know all the facts, we don't know all the background because it's settled, and we just don't have the documents, and we don't have the court filings, and we don't have the discovery that would be made. We don't have those things because they're not public, and that could be a reason for that settlement. So yeah, one of the big takeaways here is if you're a small or medium-sized employer, I do not think this is going to be a major impact on your own perm practice. I think that there might be extra focus moving forward on demonstrating good faith recruitment and making sure that if we were to have any sort of audit or anybody look into our practices, that obviously we went forward with this in good faith and we are complying with all the regulations in addition to having that good faith demonstrated. Yeah, I think by and large it's a problem for big companies and for big tech in particular, more than anybody else.
But also not a problem when you have the money for a settlement.
I mean that perhaps as well, but at the same time, when you have the settlement, it does admit no wrongdoing, but there's additional obligations that Facebook has to undergo because of it, including the potential to withdraw about 100 of their currently pending perm applications. So, if you have the money to settle, then yeah, perhaps you could get out of this, actual finding of discrimination. But there's these kind of ancillary consequences that are coming with this settlement as well. There's a lot to digest, and I certainly have not digested all of it yet myself. And I know a lot of us in the employment-based immigration world are still kind of looking through and figuring out what's happening. But yeah, that's the Facebook settlement in a really quick way. Not the most interesting thing in the world, but it is big news on the business side of immigration.
Yeah. Thank you, Zach. Right. Jennifer, you want to talk to us about the update to the travel ban?
Sure. So just this week, the White House announced that they're no longer going to be enforcing the various country-by-country or regional travel bans that have been in place since basically the beginning of 2020. There's been several different variations. Some were put out by the Trump administration and some were put out by the Biden administration. But basically, we're doing away with those. And from now on, there's just going to be a requirement that all non-citizen, non-immigrants who are traveling to the United States by air travel, so like plane or helicopter, are vaccinated against COVID-19. There are limited exceptions. I don't know exactly what those exceptions are. I think it's probably the same type of like blanket waivers or religious waivers. And again, this applies to only non-immigrants, so visitors, people who are coming to the United States temporarily. And there's a whole bunch of categories of non-immigrant visas. And we actually have a blog post going up about this. It should be up today, and there's some additional FAQs. So if you go to our website later today or tomorrow, there's several links with the Department of State frequently asked questions, FAQs, the announcements themselves from the White House and the Department of State, the CDC, Center for Disease Control, information on what is required for proof of vaccine for air travelers, and then also the White House fact sheet on these new requirements. All those will be linked to that post. So if you have additional questions about that, you can go to that post.
Great. I'm interested in looking at those exceptions because I know that they were initially saying that they would be very limited, and maybe more limited than the ones that they were granting for the green cards. And I know that we have some clients in Russia, and maybe some of those vaccines that they are accepting are not available there. So I'm curious whether or not that will fall into one of those exceptions if the vaccine simply just is not available in the country that they're trying to travel from. So.
Yeah, and I don't know if there's an exception for that. I do know that certain categories are exempt, and then also if you're under the age of 2, and in that case, they still have to get a negative result. They don't have to be vaccinated. And I know here in the U.S., they're still not offering vaccines to children younger than a certain age, but I think that's about to change.
Yeah, they're definitely rolling out changes to that all the time. It seems like I think I saw 5 to 11 can now get the vaccine, so or will be able to very shortly. So, okay, thank you, Jennifer.
Wait! I got a question for this as well. So it's
okay. You want to be the moderator now? I get it. Okay.
Hey, I can go ahead.
What I was going to say before your question, so the CDC FAQs actually list out the exceptions, and it's pretty clear. So that'll again be up on the website. But
so it's air travel only. What's going on with the border, the land border? Do you have? I know I've heard that the restrictions for Canada are going to be lifted. I believe that I've heard that the restrictions for Mexico are going to be extended. Either of you have any idea if the vaccine mandates or anything like that are going to be required for land border crossings?
I feel like they were saying that they were going to do something and then they changed the guidance for it. But I'm not entirely sure what exactly is going on with that situation with the land border.
I know it's changing pretty frequently, and I mean these new announcements are coming out, like rapid fire. So, just was wondering if you guys had heard something that I hadn't. My understanding is the same, that it's kind of up in the air, and they were considering it, but it's not. There's no announcement about that yet.
Yeah, which is, why treat those differently? Begs the question.
Makes sense, because also like boat travel, I mean, that's still a thing, right? So like ports of entry, I can't think of any good ones. San Diego.
Yeah.
So it's weird.
Yeah, because flights are you would imagine, much more likely to spread a worldwide disease than someone coming by land. So it's curious that they would, if the same requirements are, if the requirements are not the same for both. I wonder if it's what's going on there. We'll figure that out. We'll give you guys an update. Okay, well, unless anybody else has anything more to add, we'll get into questions, which we have just one question from Abush Sintuka asking for an update on Go. And just asking, when is the government going to start adjudicating? Zach, do you have? Are you up to date on where we're at with Go?
Yeah. So the answer is kind of who knows. They have a deadline on when they need to adjudicate the visas, and that's next year. So it could be that they start July and then adjudicate all the visas at that point. There's no real mandate to begin earlier than that, by my understanding. So I would expect that they're going to be doing them here and there to, I guess, get that queue kind of taken care of earlier than later. But there's no mandate that they do so, right away. It's not like the Gomez order that we had a while ago that said you have to adjudicate as many as you possibly can in good faith by September 30th. It's much more of you just have to do it by I think it's September 2022.
Okay, well, That was our only question this week. So great job, you guys.
I feel like once we got on Twitter, people stopped asking questions.
Yeah. Well, it does say that there are some. There might be some issue where we might not be able to see questions coming in from Twitter. At least that's what it's showing, that we can't, or maybe we can't post comments to those destinations, but we could still get questions from them. I'm not entirely sure about this whole system. Just flying by the seat of our pants over here. But it was really great to be able to speak with you guys. I hope to be able to do it again sometime soon. And thank you to everybody else for tuning in and watching. If you have any questions, you can come to us next week and we'll be ready to answer them.
That's
All
right.
right.
All right. Bye, guys.
Bye.
Bye.